CPLR 2019 Quiz 4. 1. In general, who may issue a subpoena without a court order? And the answer here was all of the above. It's clerk, attorney, an arbitrator, a referee, attorney general, assistant attorney general. And there may be more in that, so make sure you read 2302 super carefully. 2. Who may issue a subpoena to produce a prisoner? So now the answer here was everything except 6. Produce a prisoner. So someone who's confined under a legal process. Appellate division justice, Supreme Court justice, surrogate court judge, county court judge, family court judge, or support magistrate. And I think a court of claims judge might be on there also. And it's a New York City civil court judge if the matter was moved to the New York City Civil Court pursuant to 325D without consent. Question 3. Unless the court orders otherwise, a motion for a subpoena duce tecum for an original record or document or to compel attendance of any person confined in a penitentiary or jail should be made on 1 day's notice. Now, this is not the subpoena itself that has to be served on 1 day's notice. This is talking about a motion. So you're asking the court to issue the subpoena, and you have to make a motion to do that, and you have to give the other side 1 day's notice. So normally a motion is 8 days, 2 days, 0 days, or 16-7-1. But for a motion for a subpoena duce tecum for an original record or document or a jail person, you only have to give 1 day's notice for that motion. Question 4. A subpoena requiring attendance or a subpoena duce tecum shall be served in the same manner as a summons. Okay, that's really important. You cannot mail a subpoena. You have to serve it in the same manner as a summons. Any person subpoenaed shall be paid or tendered in advance 1 day's witness fee and authorized traveling expenses. 5. Where a subpoena duce tecum is served on a hospital requiring the production of records relating to the condition or treatment of a patient, such subpoena shall be served at least 3 days before the time fixed for the production of the records unless otherwise ordered by the court. So this is not a motion. This one is talking about the subpoena itself has to be served 3 days in advance. So hospital subpoena, 3 days, original record or document, or jail prisoner, 1 day's notice for the motion. So remember, hospital 3 days, motion for subpoena duce tecum for original record or person in jail, 1 day. 6. If a party to an action improperly fails to comply with a lawful subpoena, he may be held to contempt, have their pleadings stricken, be liable for damages sustained by reason of his or her failure to comply. Now, if it's a judicial subpoena, the penalty is $150. If it's a non-judicial subpoena, the penalty is $50. And if it's a non-judicial subpoena, you can make a motion to compel the compliance. A motion to quash must first request that they withdraw it. So you cannot immediately make a motion to quash. You first must make a request to the person that served the subpoena that they withdraw the subpoena. And if it's not returnable in a court, you would make the motion in Supreme Court. So if the subpoena was returnable at like an arbitration procedure, for example, if there's a OCA, you're suing OCA as an employee, you be in arbitration, and they want to quash the subpoena that you served, they would make a motion in Supreme Court. 7. If a person who failed to comply with the subpoena is found in contempt of court and committed to jail, they must be brought before the court by the sheriff within 90 days, and a review shall be held. The clerk shall give reasonable notice of the date, time, and place of each such review to each party or his attorney who shall have appeared of record in the proceeding. So remember, it's sheriff, 90 days, notice by the clerk of the court, and it has to be every 90 days, I think, to have a review. All right, so we're skipping 8, question 9. Which are true regarding the form of certificate administered by an official of the armed forces to take acknowledgments of deeds? So if someone's authorized to take acknowledgments of deeds, they can take an oath or affirmation outside the state or the United States if the person is in the military or something. So just remember, it's rank and serial number and the command state that they were with the armed forces at the time of the affirmation, and the serial number of the person who takes or whose dependent takes the oath. And the place need not be disclosed. So that makes sense, because if it was like a undercover operation, something stealth, then they don't want that in a public record somewhere. 10. Which, if any, are true concerning declaratory judgments? Okay, 1 is wrong. It's the Supreme Court only. If granted, note they don't have to say why. If denied, they must cede its ground, so that's true. And 4 is wrong because it may only be issued to the parties. No, this is not true. It's whether or not a justiciable controversy, if further relief is or could be claimed. That's not true. It can be done either way. And 5 is correct. It may have the effect of a final judgment. And 6, it's true. It's may be brought by a party for a claim of personal injury or wrongful death about the insurer. So what number 6 is saying actually is that, so let's say you have an accident with someone and they don't have insurance. The insurance company is claiming, oh, we canceled their policy. You can bring an action directly against that insurance company saying that they did not effectively cancel the policy, and therefore you can sue them. So that's what that's talking about in number 6, and that is true. So the answer was 3, 5, and 6. So C.
Which, if any, of the following are not pleadings? And you should know that the only one on this list that was not a pleading was the summons. So the answer was A, 1 only. Because pleadings are crap. Any complaint, reply, answer, petition, those are pleadings. Spells crap. So an interpleaded complaint is obviously a complaint, so that's a pleading. Third party complaint, again, it's a complaint, it's a pleading. Third party answer, it's still an answer, it's pleading. All right, 12. In an action for libel or slander, the particular words complained of shall be set forth in the complaint. 13, we're skipping. 14, which, if any, of the following statements are true concerning verification? 1, false. Complaint does not always have to be verified. 2, if a complaint charges a defendant with having confessed or suffered a judgment, the answer must be verified. So, a defense which does not involve the merits of the action shall be verified. So if the defense is you weren't served properly, that's got to be verified. If the complaint is verified, the answer and reply must be verified. Okay, now this is a tricky one. So the only time that that is not true is number 4. 14, now generally that is true. But there is an exception, and that's the answer of an infant. An answer of an infant would not be verified. But for the purpose of this question, the answer was B, 2, 3, and 4, but not 1. So generally, if the complaint is verified, the other pleadings are verified. A defense does not involve the merits or confessed or suffered a judgment, the answer must be verified. And in an action for negligence, just note that the bill of particulars must be verified. Okay, 15, concerning pleadings, which, if any, of the following statements are true? And the answer here was D, 3 and 4 only. I'm going to tell you what is wrong with the others. A defectively verified pleading shall be treated as an unverified pleading, not necessarily a nullity. 2, a party served with a pleading without sufficient verification in a case where the adverse party is entitled to a pleading may treat it as a nullity if they give notice of that decision to the party who served the pleading, and it's not within 20 days, it's with due diligence of receipt. 3, a party may move to strike any scandalous or prejudicial matter unnecessarily inserted in a pleading. Okay, that's true. So you can make a motion to strike a scandalous or prejudicial matter unnecessarily inserted in a pleading. 4, motion to correct pleadings must be made within 20 days after service of the challenged pleading. That is true. The motion to correct the pleading has to be made within 20 days, but an unverified thing, it's with due diligence. You have to notify them. 5, if a motion challenging a pleading is denied, the responsive pleading shall be served within 10 days of the court's decision. And no, it's after service and notice of entry of the court's order, not the court's decision. So that was incorrect. And if granted, the corrective pleading shall be served within 10 days after notice of entry of the court's order. Now, this is very, very complicated and convoluted stuff here about these pleadings. It's just something I want you to read, but you don't have to memorize. You don't have to memorize all this stuff. Okay. 16. If a party upon whom a demand for a bill of particulars is unwilling to give such particulars, he may move to vacate or modify such notice within blah, blah, blah. No, 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 no. You do not make a motion. You must object. Okay? You object to answering the particulars. Okay? So the answer was E, none of the above. Because you don't make a motion right away. You just object. So when you're answering the bill of particulars, you say, okay, this is my answer. So let's say I'm suing the Office of Court Administration for sexual harassment. They serve me a bill of particulars. They want to know, what did I wear to work? Did I kiss this guy? Did I do? And I say, okay, what did I wear to work is totally irrelevant. I object to answering that question. I don't make a motion to do, I don't make a motion about it. I just say, I object to answering this question. What, did I kiss this guy? Yes, I did. Okay, so that's how you would object. You just say, I object, when you answer the bill of particulars in writing. 17. Which of any of the following are true regarding a motion to quash fixed conditions or modify a subpoena? And the answer here is only one. And I'm going to go over why the others are not wrong. The others are wrong. So it's made promptly in the court where the subpoena is returnable. 2, promptly in superior court. No, if it's not returnable in a court, you first make a request to withdraw or modify the subpoena, and then you can make a motion to quash fixed conditions thereafter in a Supreme Court, not Superior Court, Supreme Court. And 4 is wrong because a child support subpoena, quash fixed conditions, or modify that, you can do it in Supreme or Family Court. 18. Study question. Action for personal injury, you may require all this stuff in the bill of particulars. Date and approximate time of occurrence, approximate location, where notice of condition is a prerequisite, whether actual constructive notice is claimed, statement of injuries and those claimed to be permanent, length of time to confined to bed, hospital, and incapacitated from employment. So number 18, the answer was A, all of the above. It's a study question. 19, with some exceptions, a party may serve a bill of particulars at any time without leave of court, but not less than 30 days prior to trial. Okay, so 19, just remember, that's not a 20-day rule, it's a 30-day rule, 30 days before trial. 20, within 30 days of service of a demand for bill of particulars, the party has to respond to it, except when they object, and the objection shall be stated with reasonable particularity. So just try to keep in mind that this is different than in criminal. So in criminal, you serve your demand for bill of particulars, and the defendant serves it on the people. And the people have 15 days to respond. The defendant has 30 days. Now in civil, the defendant can do this at any time, except it has to be not less than 30 days before trial. And then the plaintiff has 30 days to respond. If you're not sure about bill of particulars, the answer is going to be 30 days unless it says district attorney. District attorney answers 15 days. Otherwise, bill of particulars is 30 days. 21, certificate of merit is required in medical, dental, or podiatric actions. And I think it's also required in residential foreclosure actions. 22, which of any of the following are true? An action, okay, so this is a question here that for a very long time, the simplified procedure was not on exams, and then finally it was on exams. And the question was, what is the judgment role? All right, so read all this. It can be commenced without service of summons, continued after service of summons without pleadings by filing of a statement. It sets forth plain and concisely, it the claims of defense is in dispute and the amount of money demanded, if any, constitutes New York simplified procedure. And the judgment role consists of the statement, the motions and orders that were made, and a copy of the judgment. And it always constitutes a waiver by jury trial unless an issue of fact be raised as to the making of the contract or the submission. So what this is let's say I'm going into business with someone and we decide that if there's a dispute that arises, we make a contract that we will proceed under the New York simplified procedure, not under a regular long drawn out lawsuit. That contract, we sign it, and if I want to object to the actual contract itself and I raise an issue of fact, that's the only time I can get a jury trial. 23, a trial subpoena due to secum shall state on its face that all papers and other items delivered to the court pursuant to the subpoena shall be accompanied by a copy of the subpoena. And the answer is A. And that is, and you know, if you've ever worked in a court where you received a response to a subpoena, you have no idea what case it is if they don't give you a copy of the subpoena. 24, a subpoena to compel an original record or document where a transcript is admissible may only be issued by the court. You need a court order for an original record when you can submit a copy. A subpoena requires the attendance of a person to give testimony. So a regular subpoena, human being, testimony. Subpoena due to secum requires records and documents. 26, skip. 27, an answer may include a counterclaim against the plaintiff and a cross-claim against the defendant. Okay, so you make a counterclaim against the original plaintiff and a cross-claim against another defendant because you're sitting across the table. You're sitting across each other. Serve that on the defendant. A counterclaim you push across the counter to the plaintiff. A plaintiff who is not represented by an attorney need not serve a certificate of merit in a medical malpractice action, and that is true. The certificate of merit is only for represented plaintiffs. 29, supplemental pleading. All right, this is a simple time rule to memorize. Number 29, supplemental pleading, 15, wait a minute. Yeah, supplemental pleading, 15 days. All right, and Angela explains this in one of her crazy videos. At any time after service of bill of particulars, but no later than 60 days after the filing of the notice of med-mal, any defendant may demand that plaintiff elect to consent to damages arbitration upon a concession of liability. So a concession of liability is where the doctor or provider admits that they were liable, and then they just arbitrate damages. The plaintiff has 20 days whether or not to decide about whether to do this. Okay, 31. A subpoena to compel production of a clinical record pursuant to the mental hygiene law has to be with a court order. A clinical record pursuant to 33 the mental hygiene law has to do with crazy people. So if you have a mental problem, they cannot get your hospital record unless they have a court order. A trial subpoena due to secum for a patient so this is regular medical records in question 32, has to have an authorization signed by the patient. Okay? Otherwise, it has to be issued by the court. So the answer was A, 4 only. So you either need, for regular medical records, you need either an authorization by the patient or a court order. And for a clinical record, mental hygiene law, you must have a court order. 33, a party may amend his pleading one time without leave of court within 20 days after service or any time before the time responding to it expires, or within 20 days after service of a responsive pleading. Where attendance at the trial of a person or a party within the party's control may be compelled by a trial subpoena that may be served on the party's attorney of record. Okay, so you don't have to actually serve the subpoena on the person. If it's someone who has an attorney, you just give it to the attorney. 35. George is appearing in a trial pursuant to a subpoena, but then the case is recessed. George is told to continue testifying. What's true? 1. George must be given another subpoena showing the adjourned date. Not necessarily. 2. George may demand his witness fee, and if it's not paid, he's deemed discharged. That is true. The subpoena originally served on George must have said that George must appear on the date stated in any recessed or adjourned date for number 1 to be false, and that is true. So 35, the answer is C. It's 2 and 3 only. $36. If a warrant of commitment is issued due to a witness's failure to obey a subpoena, it shall specify particularly the cause of the commitment, and if the witness is committed for refusing to answer a question, the question shall be inserted on the warrant. 37. Certificate of merit. Remember, it's medical, dental, podiatric, and residential foreclosure for represented plaintiffs only. 38. A motion to amend or supplement pleadings shall be accompanied by the proposed or amended pleadings clearly showing the changes to be made to the pleadings. 39. Which are true? So this is a similar question to one that was on the last quiz, so hopefully you got it right. A defendant may proceed against a party who is or may be liable to the defendant for all or part of the plaintiff's claim against him by filing a third-party summons and complaint at any time after the defendant's answer. So 1 is wrong. The defendant must also serve a copy of, not the summons, it's the complaint only on plaintiff's attorney. And the third-party plaintiff must pay a separate index number fee, but does not get a new index number. So that was the only one that was true, so the answer is D, 3 only. The things that were wrong with the 2 was that it's only the complaint, not the summons, because the original plaintiff, he doesn't need a new invitation to court. He started the action, and that's what a summons basically is. It's a invitation you cannot refuse to court. And 1 is wrong because it's after the defendant serves his answer. He has to serve his answer first, then he could file a third-party summons and complaint. 40. Failure to comply with a subpoena issued by a clerk, attorney, or judge, so basically a judicial subpoena, shall be punishable as contempt of court. So when the clerk or the attorney is issuing the subpoena, they're not acting as a clerk or an attorney. They're acting as an officer of the court issuing the subpoena, and it's contempt of court if you fail to comply with it. 42. This is actually 3001. A party who has brought a claim for personal injury or wrongful death against another party may maintain a declaratory judgment action directly against the insurer of such other party. 43. True or false? When relief against a mistake is sought in action by way of defense or counterclaim, relief shall not be denied merely because the mistake is one of law rather than a fact. Now that's true. Again, I don't think they're going to go there with this on a senior exam, but I guess it used to be that the mistake had to be a mistake of fact. Now it can be either one. So an action for mistake, it can be a mistake of law or fact. 44. There shall be an answer to a counterclaim denominated as such. An answer to an interpleader complaint or third-party complaint, and an answer to a cross-claim only if the cross-claim contains a demand for an answer. If no demand is made, the cross-claim shall be deemed denied or avoided. So, there's always an answer to any complaint except a cross-claim. A cross-claim only gets an answer if there's a demand for an answer contained in the cross-claim. Otherwise, the cross-claim is deemed denied or avoided. 45. The complaint must be served with the summons. That is not true. You can serve a summons with notice, and then the defendant would serve a demand for the complaint. 46. In an action designated by the insurance law for personal injuries in the car accident case in this state, the complaint shall state the plaintiff has sustained a serious injury or economic loss that is greater than basic economic loss. And the reason that is because we have no fault insurance law in New York, so you cannot sue for regular injuries. It has to be a serious injury. 47. A verification. This is very important. What is a verification? It is a statement under oath that the pleading is true to the knowledge of the deponent, except as to matters alleged or on information and belief. That's a typo. It should say on. And that matters, as to those matters, he believes it to be true. So a verification essentially is a statement under oath that the pleading is true to the knowledge of the deponent. The deponent is the person that signs it. 48. This is true. The court may permit pleadings to be amended before or after the judgment to conform them to the evidence upon terms that may be just, including granting of costs and continuances. 49 is the first sentence is true, the second sentence is false, so this whole thing is false. Pleading shall be liberally construed. That is true. I want you to know that that is true. But defects shall be ignored. Ignored, not corrected, if a substantial right of a party is not prejudiced. 50. Motion to quash, fix conditions, or modify a subpoena shall be made promptly in the court where the subpoena is returnable. And 51. If a subpoena is not returnable in a court, so it's returnable in front of an administrative board or something like arbitration or something, first, a request to withdraw or modify the subpoena shall first be made to the person that issued it, and a motion to quash, fix conditions, or modify may thereafter be made in the Supreme Court, except child support subpoena. It can be made to Supreme Court or to family court.